Okay, so here's what I'm gonna do. I'm not saying no to what your request is, okay? What I'm gonna do is I'm gonna put it over a week, let that process happen. If it doesn't work out or whatever happens, then we can do the waiver next week.
Welcome back to Myth and Reality, where real people face real justice, and today's docket is packed with drama. First up, we've got People versus Larzell Washington. Now, Washington's case might sound straightforward at first, but the stakes are actually huge. He's facing a felony charge that could follow him for life. But here's the twist. The judge hints there might be a way to keep this from going felony altogether. That's massive, because if Washington plays this wrong, say, waiving a preliminary hearing too early, he could lock himself into a future with no good options. You'll see Washington himself push back, argue about his circumstances, and even clash a bit with the judge's process. And as if that wasn't enough, another defendant, Montel Gatlin, steps up later with his own courtroom showdown, trying to reject his own lawyer mid-hearing and fighting to get his bond reduced despite serious charges. This session has it all: emotional pleas, legal strategy, and a judge who keeps control with sharp authority. Stay locked in, because these cases show exactly how fast courtroom decisions can make or break a defendant's future.
Court calls case People versus Larzell Washington.
Okay, original judge for the people.
Ed Rodriguez for Larzell, Washington.
Larzell and then Washington, sir.
Thank you. All right, what are we doing?
Your Honor, we adjourned it a week. I had reached out to the recovery court, and Mr. Reyes, his interview date is set for tomorrow.
Pardon?
His interview date is set for tomorrow.
So he's gonna be interviewed
He's
tomorrow?
going to be interviewed tomorrow.
All right, so will they get an answer within a week?
I assume he'll get an answer really quick.
Okay. So I'll adjourn it out one more week to the 29th then.
Period.
June 29th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Excuse me. I would like to waive my circuit court. Thank you.
You want to waive your preliminary examination?
That's right.
Here's where things get tricky. Washington wants to waive his preliminary examination, a critical step in a felony case. For context, the preliminary exam is basically a mini-trial where the court decides if there's enough evidence to move forward with felony charges. Waiving it can sometimes speed things along or pave the way for a deal. But here's the danger. Once you waive, you lose that chance to challenge the evidence early. The judge clearly doesn't want Washington to jump the gun, because there's still hope of negotiating this charge down. Smart move by the court. Sometimes protecting the defendant from himself is part of the job.
And
Have you talked to your attorney about that?
Your Honor, if I could approach with counsel.
Yes. Washington, you want to waive your preliminary examination. Your counsel's asking that I adjourn the probable cause conference. Certainly, you have the right to waive it, but usually people do that in consulting with their attorney. Okay? Now, just listen closely to me. My understanding is that there is the possibility of working this thing out in a way where there may not be a felony for you.
A what?
Okay.
Pardon me?
Did you hear me or no?
No, I didn't.
That there may not be a felony.
I understand.
Okay. So that may not happen if you waive.
This moment right here is huge. The judge tells Washington, there may not be a felony for you. That's about as close to a lifeline as you're going to hear in open court. Imagine the relief, but also the risk. If Washington ignores this and insists on waiving his rights prematurely, he could ruin a potential deal that saves his future. This is where courtroom patience pays off. What do you think? Should Washington trust the process? Or is the system just dragging things out? Drop your take in the comments, because this is the heart of courtroom strategy.
Okay, so here's what I'm gonna do. I'm not saying no to what your request is, okay? What I'm gonna do is I'm gonna put it over a week, let that process happen. If it doesn't work out or whatever happens, then we can do the waiver next week.
Right.
Fair enough?
I'm actually going to be fine. No, just wait. One of them.
Your Honor, he's asking for a PR. I mean, I don't know if the court would allow him to get the interview conducted tomorrow.
Once I get an answer from hang on a second, Mr. Washington, you gotta listen to me now.
Yes, sir.
Okay, so once I get an answer from that, I'll consider release on a PR. Okay, I'm not saying that I will, but once he does the interview and I get some information from that, then I'll consider doing something.
With all due
Okay?
respect,
But-
Your Honor, I was supposed to been had this business taken care of with this young
Is
man.
what?
Would you explain to him I was supposed to been had this taken care of? Please send me.
No, he's explained that to me.
Okay.
I understand that.
Well,
It's not.
I just rather let it go through, let it play the role, because I'm not gonna keep coming in here every week going through this. I'm saying $174, good Lord. Y'all letting people out with worse things than that.
Now this is raw. Washington breaks down the reality of his life. He's homeless, his father is in the hospital, and all this for a $174 issue. He's basically saying, people with way worse charges are walking free, but I'm stuck here. You can feel his frustration boiling over. This is where the courtroom becomes more than law, it's human. Judges hear these kinds of pleas every day, but the weight of someone's personal story can sometimes tip the scales. Would you show leniency here, or do you think the rules should stay strict regardless of circumstances?
You know, it's been a month. Forgive me. I was homeless. I missed court. My father's in the hospital. I'm a working man. If you check my check record, my unruled ground record, I don't go to jail.
Mr. Washington, I usually don't adjourn a week out. I usually go in 2-week intervals.
I know I've
I'm
been
trying to get you before the court as quickly as I possibly
right,
can.
but I've been back,
Yeah.
sir,
Yeah.
with all due respect, a month. You know, I'd be a fool not to show back up in court in front of Judge Simpson anyway. You know, I'd be a damn fool if you let me go not to show back up. But
That's probably accurate.
right,
So
you know, with all due respect,
no,
right, but
that was a heap of respect.
right, I'm just saying,
I'm good.
you know, my father is ill right now.
Mr. Washington, okay. I know you may want me to do it a different way, but you also know me well enough to know
Well, I
I'm
don't
gonna do it my way.
well,
I'm gonna hear everybody out, and this is the way I'm gonna do it. So I'll see you next week. If at that point the stuff that's supposed to happen doesn't happen, then I'm gonna deal with that. I'll let you waive. I'll let you do whatever you need to do. But I don't want you in a circumstance where you might be hurting yourself. If something worked out that's going to be beneficial for you, then let's get it worked out and let's get this thing moving. All right?
Classic Judge Simpson moment. He reminds Washington and everyone else that this courtroom runs on his terms. It's not arrogance, it's authority. Judges have to balance compassion with structure, and Simpson makes it clear, I'll hear you out, but I'm doing it my way. It's a reminder that no matter how emotional the plea, the process has to remain intact. That's the tension in court, personal hardship versus legal order. And Simpson, love him or hate him, always makes sure the scales don't tip too far either way.
Court calls the case people versus Montel Gatlin. Shaquila's back there all. She's like, why do you call me out like that? The prosecutor say something.
No. Sorry, Jennifer Gatlin.
Assistant Public Defender Chelsea Virgils with and on behalf of Montel Gatlin, please state your name.
My name is Montel Gatlin.
Thank you. What are we doing?
Your Honor, we are asking to set the preliminary exam in both of these cases. We do not have discovery in one case. I informed my client of that. He does not wish to waive the 21-day timeline in these cases. He asks to set preliminary exam regardless of knowing we don't have discovery on one case.
Which, yeah,
I mean, may I speak?
if you want.
I don't want her to represent me.
And just like that, we've got a whole new case, and this one's explosive. Montel Gatlin tells the court, straight up, that he doesn't want his public defender representing him. That's a bold move, but here's the reality. Defendants don't always get to choose their court-appointed attorney. Judges know public defenders are overloaded, but they also know these lawyers are some of the best in the business at handling tough cases. So when Gatlin says she doesn't have my best interest, the judge pushes back hard. This is a fascinating clash, client distrust versus courtroom reality.
Okay, so you don't get that choice necessarily, but why?
Because just conflict, like we had a back and forth back there in the back room. Like, I don't think she has my best interest.
Really?
Yes.
Why? Because she wouldn't do it you?
Huh?
Because why do you say that? Because I've never known Mr. Deals not to have her client's best interest at heart. Ever.
By the things she said, this
A lot of things that she said you may have disagreed with, right?
really all things.
Okay, all she said. Sometimes that's a lawyer's job. Sometimes they have to give their client the hard facts of what's going on. And they have to do that they have to give them their legal interpretation of what's going on, which may not suit with what you want to happen in the world. But they just give you a steady dose of reality. So if you disagree with her legal analysis, then fine, but show me your law degree.
No, I'm disagreeing with her legal advice.
Okay, and you're doing that with your legal degree that you have, right?
No, she was.
Yeah, that's what I thought.
No, I don't have a legal degree, but
I
she was
know.
trying to get me to waive things, and like I was telling her, it would kind of waive my rights to 180 days into trial, right?
She
And-
just got before me. Did you even listen to what she said? She has indicated that you don't want to waive any statutory period. So she listened to what you said. She told me that, and I was going to set these for exam. Anything else?
Yeah, I don't want her in my case.
Well, she's on your case.
Your Honor, I would ask to also address bond if possible.
Yes, you may. Hang on a second. Let me set the exams in these cases. And which case don't you have discovery on that he's trying to set it before you guys get a chance to even look at it? That makes so much sense, but go
We're
ahead.
asking media discovery on 25 FB 1090.
On 1090?
Yes, Your Honor.
Discovery on that one is not complete. I'm going to note that. Do people have their witnesses available on the 3rd? Pardon? All right. Preliminary examination in these matters will be set June 3rd, 2025. 9 a.m. That's before me. Right? Those both come before me.
Now we're in the heat of it, Bunt. Gatlin's attorney argues $50,000 is too high, pointing out he has a job, church ties, and a life to return to. But the prosecution isn't buying it. They hammer on the serious charges: child abuse, fleeing police, and a firearm. That's not small stuff. The bond decision here isn't just about money, it's about risk. Is this man a danger to the community? Will he run if released? That's the calculation. And the judge? He holds the line. Bond stays where it is, at least for now. Do you agree with the judge, or should bond be lowered for working-class defendants with roots in the community?
Sir, in person, as to bond.
Your Honor, we're asking the court to consider lowering the bond on case 25 FB 1142. Currently, it's set at $50,000. He's asking you to lower it to the same amount as his other case, $1,000, 10%. Mr. Gatlin is an Ypsilanti resident. He is employed as a plumber. He at least was before he was in custody and plans to go back to that work. He's involved with his church. He plans to abide by his bond conditions. At this time, he's been in custody for 11 days now, and he is being held until May 29th on a case with Judge Washington. His sentencing is May 29th on that case. So he hopes that the bond will change at that time and that he'll be able to be released. So we're asking you to lower to something he'll be able to pay
So he's being held on a case before Judge Washington now.
until May 29th,
What's the proceeding on May 29th? Do we know?
sentencing.
Sentencing. What kind of case is that? Do we know?
I don't know, Your Honor.
All right. Response from the people?
Your Honor, we've asked the bond to stay the same. We think it's appropriate. He does have multiple pending cases at the same time. The case in 1090 is a stolen case. This case has concerning elements of that. He's accused of child abuse, but also fleeing police and possessing a firearm. We believe he's both a danger and a flight risk, and we think that this bond is appropriate.
All right. In this case, what I'm going to do is I'm going to deny the request for a bond reduction in this case and leave his bond in place. If something happens on the 29th, before you're, because that'll be about 4 days before you see me. If something happens on the 29th where he's eligible for release, then you can contact my office and I'll reconsider this decision. All
Thank you, Your Honor.
Thank you.
2 cases, 2 very different courtroom battles. For Larzell Washington, the judge's patience and insistence on process could mean the difference between carrying a felony forever or walking away with a second chance. For Montel Gatlin, the fight isn't just about his charges, but about trust in the system, his lawyer, his bond, and his future. What these cases show us is simple. The courtroom is never just about facts. It's about people, stories, risks, and strategy. And as always, Judge Simpson made sure his courtroom stayed firmly under control. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns right here on Myth and Reality.